No sugar. Thank you.
Okay, members, we are live. Before we start the meeting, can I check that everybody online can hear us? Yes, thanks, Morris. I'm presuming then that...
I can hear you, yeah.
That's great, thank you. Yep, Doug's saying yes, and I presume Justin can too then. All right, so we call the meeting to order. So welcome, members. This is the 14th meeting of the Committee for Justice, and it is the last one of this session. Try not to gently weep. The meeting is now open to the public, so if there's anybody outside, they're welcome to come in. The committee is going to be recorded and broadcast throughout Parliament buildings and online. And we have Justin McNulty, Morris Bradley and Doug Beattie with us virtually. I presume that we have an apology from Alex Easton. I haven't heard so far, but apology from Sinead. An apology from Sinead. Okay, thank you. Members, we are obliged to declare financial or other relevant interests that might reasonably be thought by others to influence our approach to matters under consideration. Any member who does have an interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Does anybody have any interest to declare at this stage?
I think it's in correspondence of a family member works in the court service.
Thank you, and I'll declare that I have an immediate family member who works in the legal profession. Those are fairly standard now, I think. That's great, thank you. Agenda item 2 is draft minutes of the meeting held on the 13th of June. These are at pages 5 to 13 of your meeting pack. Are members content that the minutes are a true and accurate reflection of the proceedings of that meeting held on the 13th of June?
Read.
Thank you. Then I'll sign the minutes. Any matters arising? We have none. No, anything's covered in the agenda anyway. Thank you. Agenda item 4 is statutory rule, the Police Pensions Remediable Service Amendment Regulations, Northern Ireland 2024, and this is at pages 15 to 27 of your meeting pack. Members, just before we get into this, there's one thing I want to apologise to you for the tabled papers. As it turns out, the tabled papers were as long as the pack itself. So I suppose I didn't fully appreciate the extent of it, and I'll not make that mistake again, and I'll check in future. However, that said, I think given the nature of some of the items in the table pack, it would have been remiss not to table them. Bearing in mind we're not going to meet until September, so I'm not sure the decision would have been different. However, I do appreciate that if we're getting 3 days to read 250 pages and then less than 24 hours to read another 250, it's not ideal. So I take that in the chin, and apologies for that. We'll try to ensure that the table packs are not to that extent unless in an emergency situation. So if we can turn to agenda item 4 then, this is the statutory rule around the police pensions, which we have previously considered. So you'll recall that the purpose of this statutory rule is to further support the scheme manager and pension administrator to effectively deliver the MacLeod judgment, which is the retrospective remedy, and to correct omissions and minor drafting errors. So at our meeting of the 13th of June, the committee agreed that it was content with the proposal for the statutory rule. The department has confirmed that there have been no changes to the policy content since the proposal was considered by us, and the rule was laid in the Business Office on the 20th of June 2024 and will come into operation on the 22nd of July, although it will have retrospective effect from the 1st of October 2023. I suppose it's important to note that the examiner's statutory rules hasn't yet reported on the rule. Do members have any comments, or are you content with the rule?
Content, yeah.
Thank you. So if that's the case, then I'm going to put the question. The question is that the Committee for Justice considered Statutory Rule 2024-138, the Police Pensions Remediable Service Amendment Regulations, Northern Ireland 2024, and subject to the examiner's statutory rules report, has no objection to the rule. Members agreed?
Agreed.
Thank you. Agenda item 5 is SL1, is an SL1 Insolvency Amendment number 2 Rules, Northern Ireland 2024, and these are at pages 28 to 35 of your packs. So from memory, this is around, so I'll give you the background and then the detail that I think is important. So this rule will amend the insolvency rules in Northern Ireland 1991 in relation to the financial limits for eligibility of the Northern Ireland Debt Relief Scheme. It's proposed that the scheme in Northern Ireland will continue to be aligned with the scheme in England and Wales. And as far as I know, essentially all this means at this juncture is that previously the asset with regard to repossessing a car was £1,000 and then was subsequently increased to 2,000. That's now been increased to 4,000.
Yes.
Now,
They're increased to 4.
that's the only change, isn't it? Is there any other change with regard to the eligibility of the scheme, or is that it's purely just about that the seizing of that asset, isn't it?
Yep.
Am I reading off it?
Yes, and it's similar to England and Wales.
Yeah, I just want to be clear that that's the only one there is, because whenever you hear about it's going to amend the financial limits for eligibility, I just want to check that that's all that it is.
Yeah.
So this will be subject to the negative resolution, which presumably means it won't appear in the Assembly unless anybody decides to pray against it. Is that right?
That's right.
Right. So, are members content with the proposed rule? Do you require any further information, clarification, or do you wish to comment on the rule? Because I think sometimes we're just asked, do we want further information or clarification, but I think sometimes the department's also seeking our views on things. I mean, what are our options in terms of SL1s?
You could certainly write to the department chair, or you could seek further information and ensure that members are satisfied that you're content with the proposal. This is the time that members have to shape the proposal, and the only time really, because you cannot amend a statutory rule. So it's the time that you have to influence it.
Okay. So it's right. I mean, I appreciate this one potentially is not very controversial, but just so that we know what our options are in future when considering SL1s. Is everybody generally content? Anything they want to raise? Everybody's happy enough, or?
No, I think happy enough. I know there was the issue around consultation, but the department was satisfied that this goes beyond even what respondents had initiated. So, which was the 2,000 upper limit, and now it's moving to 4.
Yeah, and,
So
and
I would
actually,
say
I think
most
there
are-
was reference to 4,000 within the consultation, and
Yeah.
people had indicated if it were to move,
That's
they would
right,
be happy.
they
so we
increase
agreed.
it. So I think that kind of underscores then in terms of the consultation. But as you say, maybe just a bit more as the reports are coming forward from the department, clarity, just to make it clear in the papers then that we're getting around SL1s and stuff, that it's only this element of the overall rules that we're changing or not, you know, so just to really set that out more clearly, I suppose. That's more a presentational issue maybe, so.
So are members content then, yes?
Yes.
Yep.
All right, thank you.
Content.
Agenda item 6 is another SL1, compensation orders, disqualified directors proceedings rules. So this is at pages 36 to 43 of your pack. This rule is going to make provision for a procedure to be followed in proceedings in the High Court relating to compensation claims against a disqualified company director. The Insolvency Service in the Department for the Economy is the policy lead for this rule and was therefore responsible for drafting it. The Department of Justice then undertakes the necessary scrutiny and procedural steps in having the rule made. The rule will be subject to the negative resolution procedure, and executive approval will be required following consultation with the Committee for Justice and the Committee for the Economy, because it's cross-cutting. So again, are members content with the rule? Do you have any further information that you would like? Do you need clarification, or are there any comments you wish to send forth?
No.
Everybody's content? Thank you. Yeah. Agenda item 7 is another SL1, the Court of Judicature Amendment Rules, which is the working title. The details of that are to be found at pages 44 to 50 of your meeting pack. This rule is going to amend the Court of Judicature rules to provide for a 28-day time limit in civil cases for a party to seek leave from the Court of Appeal to appeal a decision of that court to the UK Supreme Court. The proposal to introduce a 28-day time limit in England and Wales has also been made, and that Scottish legislation already provides for a time limit of 28 days to lodge an application for permission to appeal to the Inner House to take an appeal to the Supreme Court. Again, this rule is going to be subject to the negative resolution procedure. Are members content? Do you have any further information you'd require or clarification on any issue or any points you want to make?
Content.
I suppose the only thing I would like to flag up is that it's quite a jump. I appreciate that it brings it into line with criminal appeals, but it's quite a jump to go from no time period to a 28-day limit. So if that's going to be the case, I think it needs to be widely publicised amongst the profession so that nobody is caught out. You know, I think it would be important that the profession would know.
We could ask that then in responding to it, just what plans have the department got to communicate this?
Yeah, and I think express our view that it should be widely communicated in order that everybody's very clear and that
Presumably the case
people
by,
don't lose out.
presumably on a case-by-case basis, judges who are perhaps advised at the time of a case that that a client in front of them is going to appeal, one party or the other, can be also reminded. I think at the point of where you're told you've got a decision and you feel that you want to appeal that decision, you should be reminded that you've now got 28 days.
Yeah. Fear steered is in circumstances where somebody's been given a decision and feels they have time to mull it.
Yes.
And before you know this comes in, then they think they've got time, and it turns out they've got 28 days, and neither their advisors or or themselves understand that. So, because that is quite a move, although albeit it keeps us in line. So I suppose we can flag that up to the department. So if we flag that up to the department, then are members content?
Yes.
Yeah. That's great. Thank you. Agenda item 8 is the Department of Justice Business Plan, which is a written paper. And this is pages 3 to 18 of the tabled pack. This is a substantive item on our agenda, and the papers weren't included in the main pack. Instead, they came in the tabled pack, which is disappointing. I would like it if substantive items, unless there's an emergency, that appear on the substantive agenda should appear in the main pack and not a tabled papers pack. The department is well aware of the deadlines. So I know people are under pressure. I know there are resourcing issues. However, you know, the schedules are fairly clear. I know things can arise too, but I think as we head into September, I think I would like that approach to change, and that where possible, unless there's an exceptional circumstance, that stuff would be in the pack when it's supposed to be. So they have.
For clarity, are you wanting to write to the department to that effect, or shall I speak informally, or just to say clear agreed action?
Well, I'll take guidance from the committee on that. Do you want to write? Are you content that Caroline speaks with the DALO? It's not the first time we've raised the issue.
I think we could send a letter just saying, look, just set out, you know, we do need the time then to kind of go through the paperwork and stuff. I mean, I would be keen probably when we come back after recess anyway to maybe just touch base with the department on all of the work programmes and kind of where we are. And then just in terms of our own committee planning day around, I know Caroline's put some of it in terms of the forward work programme, but just to kind of, if there are any specifics on the business plan that we'll want to pick up on. Obviously there's items in the correspondence as well pertaining to legal advice on the High Court ruling and stuff recently, so maybe just to touch base and refresh ourselves after the election and stuff in September around all of these, but maybe to communicate to the department that yes, we need advance, you know, the information needs to come in the deadlines, and would be keen to engage then after recess.
Was it the case, Chair, that we should have had this in advance of today in order to read it, or was there an expectation that there'd been a further week of committee meetings without setting the election aside?
I'm not sure, Stuart, but the issue is if it was a substantive item on our agenda for today,
That's fine.
then the paper should have been in
for today.
to be issued to be issued with the pack on Monday.
Yeah, no.
I note that there are a few red items on there, a couple of liberties with the green ones, I think, in terms of interpretation, but there are a few red items there that are of note. And you know, if you just take a quick look through, I know we're trying to get through things today, but on page 8 it seems there that there was working with partners to support improved mental health within the justice system, and that has stalled due to resourcing pressures with partners. And that's I mean, that I think forms part of our inquiry. Deirdre?
I know I was going to touch on that one because I know it comes up later in terms of a report into death of McGabry and stuff
Yes.
pertaining to similar issues and around the health service, and it's an issue obviously we've been discussing in terms of the intersectionality between health and health provision, particularly in the prisons, and then the Justice Department more widely. So I think definitely, I mean, I would be keen to come back to these issues again, and maybe, you know, we can prioritise where we feel the priorities are, to have a more in-depth oral briefing with the department just to kind of
Yep.
get into some of them in a wee bit more detail. And I know at some point we're obviously looking at joint committee between health and justice as well. I think that would be good around these issues, because there are concerning between this business plan and obviously the correspondence as well.
Just if I could draw your attention then to page 10, around the prisoner ombudsman. There were proposals to move this to statutory footing and address a backlog of complaints cases. It says there the competition was run for the role of prisoner ombudsman, but the successful candidate withdrew. And I appreciate an interim arrangement has been put in place, and it seems to be Jackie Durkin from Sujani has taken that forward. But I'm wondering, would they have a better chance, you know, of recruiting somebody for that post if it were on a statutory footing? You know, what is the impact of the statutory footing or otherwise on recruitment of a prisoner ombudsman?
Yeah, attracting somebody.
Maybe we could ask something around that. The other one is on page 16. Which is around the policing board and providing an evidence-based strategic framework through which the Northern Ireland Policing Board can create the policing plan. It says it wasn't achieved due to resourcing issues, work was not progressed as planned. Following the restoration of the Assembly, the Minister of Justice agreed that work on long-term policing objectives should be paused until the next cycle of strategic planning for policing by the Policing Board, which seems straightforward enough, but I think we would like to know, well, when is that likely to be? When is that work likely to proceed? So when does the board next engage on strategic planning for its objectives? So beyond that, and we may, are we content to write to the department about those issues and note the rest of the paper for now, but indicate we're likely to come back to it?
Yeah.
Okay. Thank you. Agenda item 9 is the forward work programme, which is at pages 53 to 66 of your meeting pack.
Do we start that first week, or I always thought it was, is it the following week, or what way?
Entirely up to members, and you can, so I just penciled in a visit, but you don't need to do anything that week.
I know, I just wondered, sorry, it was because I always assumed it was
The Assembly doesn't sit until
the 9th.
yeah.
Nights.
So you don't have to do anything then.
So I suppose the issue is, well, the thing that I'd be weighing up here is, we've postponed this once. I don't want the court service to, they've got to go out of their way for this. So I don't want them to arrange this if we're not going to be here. And I know some people don't, some people take their holidays kind of at the end because it's a bit cooler in September. So I don't want us to schedule something in if we can't, if we can't produce a reasonable turnout. So if we are going to do this in September, we'd absolutely need to be sure that we're going to have sufficient numbers. Any members have views about it?
I'm definitely not available that week. I'm not in the country.
I think we'd better go into the 12th.
I'm just thinking even the 12th has the potential in terms of the justice bill, but that's probably not likely going to go through until there's a meeting of the executive. Then,
Which,
sure,
which will be the first week.
that may free up the 12th to allow us to do that visit. If we want a visit on the first meeting back, I don't know. But
When does the executive meet?
well, I don't know. That's what I mean. I don't know. I don't know if it would be in time for
There is a rumour that there may be a recall.
Well, let's be honest, Stuart, there's recall every time we have summer recess.
I know, but specifically at the face on, yeah.
Martin.
So
But-
that's
but
not
to
really
do this, yeah.
Where do you want to put it? Maybe do a meeting here for the first week on the 12th, and then maybe do the court visit after that.
I suppose the issue is for what's on the schedule there for the 19th, if that were to be brought forward for the 12th, but would Reyes have the briefing paper ready by that stage?
Yes, they will be ready, Chair. I think they nearly have it finished actually already. So
Oh, so we could switch those out. Do members online have any views on this?
another
Anybody?
option, Chair, would be to wait until.
I'm easy,
Any-
folks. I'll take your steer. I'm easy.
Thanks, Justin.
Yeah, same here. I'm happy enough to take steer from you good people in the room.
The other option would be to postpone until members are sort of deeper into that scrutiny of that bill, which may have some provisions relating to the court. So that could be another way to tie it in.
Yeah.
And so you could postpone it and
Make it
we could come back to it.
I think whenever we decide to go, the paper that there is in the tabled pack about the court services annual business plan, it would be helpful to have that re-tabled in advance of the visit.
Yeah.
Okay, so we'll keep that kind of as fluid. We're going to meet anyway at the start
And
of
we'll look
August,
at
and we
the
can
work
take a look
programme.
at some of this stuff. And
Chairperson, nothing on the 5th then, just for clarification.
well, no, nothing on the 5th. I think we'll just start it. Members can tend to start in on the 12th. Yeah.
Yeah.
Okay, thank you. In terms of the work programme, I suppose just a few initial thoughts on looking at it. The right person, right care in November seems a bit far away. Did they suggest that, or?
Yes, Chair, we'd met with PSNI officials and they suggested that would be a good time to have that briefing, and indeed the AAC is prepared to come to that meeting, and the Committee for Health also can hold the concurrent meeting that day.
Okay, just seems like a long time away for what is a very serious issue that I think is not being taken forward or being treated with the gravity it should. I'm not sure we need. Are we getting Gillen updates every quarter at the minute?
Chair, members agreed we've only had a written paper so far, and members agreed to have an oral evidence session on that in the autumn winter,
So when is it scheduled for?
the 12th of December.
Okay. I just want to be sure that we're not repeating the same things over and over again at the expense of other subjects that we haven't touched. That's my fear. But that's fine. Likewise with the IMB, I think we're coming on to something around them, aren't we, in correspondence?
Mm-hmm.
Right, so I want to make sure that we're dealing with the stuff that's absolutely important, not bringing people in here unnecessarily or too frequently at the expense of others, but just making sure we get the balances right. But we can work through those things. So beyond that, are members content to note then? Is there anything else you want to add into the forward work programme?
I think, sorry, Chair, we'd said at the last meeting that we would sit down and meet, and we're going to due to meet over the summer, so we could kind of look at this in a bit more detail and then send that out to members in terms of just being signed off and agreed, you know, taking into account obviously those that have requested areas of work that we've been raising as a committee, but then also from the planning day as well, which I know some of it's in the work programme in terms of post-bill scrutiny and stuff. But just if we take a closer look at it then when we meet up with Caroline and stuff, and then send that out to the committee then to see if they approve it then at the next meeting.
Yeah. I think it also would be helpful, Caroline, if you would furnish the Vice Chair and me with a list of the requests for meetings, and then we can prioritise. And you've sent some out and I haven't had a chance to get back to you yet. But then we can establish so that you're not kind of chasing
You
things.
know, I have, it should be, hopefully it's in your inbox already, that one.
Yeah. Of the list of requests?
Yeah, because I've arranged meeting for those that we're able to, and there's another one outstanding at the moment, which I've mentioned in the email.
Okay, so that's all. We've just got the 3.
Yes, unless you were any further today.
That's perfect, thank you. Okay. Right. So forward work plan we have dealt with. Agenda item 10 is correspondence. So the bulk of our papers actually are correspondence between the tabled pack and this pack. So there's a correspondence memo and 21 items of correspondence at pages 69 to 223 of the meeting pack. I'm going to draw your attention to a number of the items, and then you'll all have an opportunity to comment on any other items of correspondence in which you have a particular interest. Could I draw your attention to item 8, which is an invitation from the Northern Ireland Judicial Appointments Commission, which is at page 133 of your pack, to an event relating to judicial appointments in Northern Ireland in February 2025. The correspondence includes a briefing paper. We're being asked to consider having a joint committee event with the Committee for the Executive Office in February 2025. It's proposed to be some kind of lunch and over 2 hours. Do members have any thoughts or views on this? Are you content to do that?
Would be content. Yeah.
Yeah, the only issue I'm thinking is I'm not sure. I thought the Executive Office Committee met on a Wednesday.
They do.
So I'm just wondering in terms of scheduling that, how it could be difficult enough, but we'll see what we can figure out to spring.
Is there a day that, or a time that suits most members of the committee best, Chair, just to go back with?
It'll depend. You're not going to get everybody, I don't think.
No.
Because I have committee Wednesday afternoon, Ciara's committee Thursday morning, so I don't know about Wednesday morning, what's on when TO's in the afternoon, isn't it? On a Wednesday.
Infrastructure's on, isn't it? I'm not sure what.
In terms of what other members would be on, but maybe, I don't know, Wednesday morning, unless somebody says they're at a committee, I don't know. I suppose it's just trying to get as many from both committees, because
Yeah.
it'll be a struggle to get. So just we agree to do it on the basis of whoever can attend then to attend, yeah, to try and
Though I think
at least have a quorum.
at least one of us should be there.
Yeah, no, that's no problem.
Is it just Wednesday morning?
I think potentially, yeah.
Yeah, I can do Wednesday, Thursday morning, but that would exclude maybe others that are on communities and stuff.
Yeah, Thursday could be difficult for
Oh,
me
aye,
with
it's
Windsor
the
Framework,
Windsor Framework.
but it depends because sometimes that finishes early and sometimes
right.
it doesn't.
So maybe Wednesdays then. No bother. Yep, great.
We're agreed to try and schedule that.
Yes.
Thank you. Before I move on to can I just work through this in terms of there's item 11. Yes, there is correspondence from the IMB at page 188 of the meeting pack. We're being asked to note this item and consider scheduling an oral evidence session with the IMB in autumn winter to provide an update on its work. How quickly do you want to have that?
I'm wondering, could that be, I know there's the potential of a visit back to McGabry in terms of prevention and stuff. Now, I know we met some of the members there. It was only me and Ciara, obviously, at that point, so, but we'd met some of them who go to the prison, and I thought that was actually really informative as well. Is there a way that we can do that again, maybe, and meet them on site?
Yeah.
Or do you feel that it's better in this format? They had a wee room there, like that they could facilitate us in, and then the prison service obviously left, you know, so they weren't sitting there kind of watching, or so it was kind of a private meeting with the Independent Monitoring Board. But maybe I'm just trying to put too many into one visit.
I think it might be. I think that I think it's helpful to have them in the formal environment as well.
Yeah.
But also, you know,
Or maybe to meet them then
You can
before
ask
we go
different
back
questions.
to McGabry or something.
and then there are areas that I would like to explore with it. I mean, we have 2 reports in front of us today about very sad deaths in custody.
100%.
And in both circumstances, indications were that the gentleman concerned were okay and had indicated that they were okay. So very difficult circumstances, and I wonder if we could, obviously IMB inputs into those reports in the Prisoner Ombudsman, and I wonder if it might be an opportunity for us to ask some questions around, is the environment one where if a prisoner is struggling, is the environment one where you can admit to having thoughts that are detrimental, and if they do admit to such thoughts, what are the implications? What happens next?
Yeah.
You know, is there anything within that that would prevent somebody from coming forward to say, I'm considering this? I mean, I appreciate that with this subject, it's highly emotive, very sensitive. It may well just be that people don't want to admit anyway because they don't want their plan thwarted in that sense. So, but I just wonder, are there questions we can ask around this? And I think certainly there are questions that arise out of the reports, which we'll come to in due course. But I would like input from the IMB on that.
Maybe a part of a dedicated committee meeting on it, because there's been a couple of issues. I mean, it was even in the news a few weeks ago around a death, and obviously there's the thing around having a centre-based approach, looking at a needs assessment when you go in. I mean, I know even CARE's raised it in terms of even the confinement and stuff that people are put into in some of the prisons as well. And I think there's been issues coming up around the health trusts, and again that link up, or maybe it's a bit too disjointed. So maybe have the IMB, and there may be 1 or 2 others that we'll want to speak to in front of the committee, and kind of take an evidence session at one of the committees looking at a range of issues in our prisons.
I would very much welcome it as well, and I know I've met with a family who's awaiting a report where their loved one has also lost their life in Maghaberry 2 years ago, and I know they've been meeting with the Minister awaiting outstanding report. But I've also been liaising with the family quite recently. Young man, learning disabilities, severe health needs, total lack. Mother is the full-time carer. And just total lack of communication between the full-time care and prison service, where I'm having to liaise on behalf of the parent, but then likewise trying to get through to the family support team within the particular house that the young person is in has been a nightmare. It's been 2 weeks to try and get any communication. So there's something there. It may be there, only families aren't aware of how, particularly if you're the full-time carer of that individual, regardless of what they're in there for, there needs to be more effective communication because that person knows them best. I was nearly having to support the family who were nearly about to, their health was deteriorating, the fact that of the unknown, not being able to communicate about their child and the support that he needs whilst he's in there, due to the range of health issues that he has. Yeah. They're relying on that individual to communicate it. That individual wouldn't have a full-time carer if he didn't need someone to actually communicate as well on his behalf. So there is issues, and it's maybe just total more clarity, and of the families need more clarity of how to navigate the system if a loved one is in prison. So
yeah, I think that, I suppose, the 2 reports we have in front of us are distinct in that it was at the time of the COVID regime, a very difficult time for all concerned, including officers, and they were trying to balance multiple risks. So a very difficult set of circumstances for all concerned. So I think that leaves us with questions around, okay, you know, is the assessment of somebody's propensity for self-harm enough? There clearly is an issue around information sharing at every level, and we appreciate that patient confidentiality has to be protected. But in circumstances where information could help prison officers to save a person's life, you know, I think that these risks have to be weighed up. So you know, there are a number of things here that I think we can look at, and I accept from the reports that the prison service and the health trusts have agreed with the reports and have agreed to take action. I think we would want to follow up as to whether or not that has been taken. But it's very, you know, it's very difficult, and I think we want to handle it sensitively, but also try to get to the root of the issues. I mean, the purpose here is to try to make everything better for everybody concerned, including officers who will be highly traumatised at coming upon that. And people also have commented on the nature of how family members are informed of a death in custody, which appears to be very difficult for all concerned too, including those who have to make the phone calls. So, Stuart.
Chair, I think there's also a role, we need to look at the role and access that the third party sector has in terms of Samaritans and other organisations, both in terms of training for prison staff and in terms of access for prisoners 24/7. And just as a simple phone on the wall, insufficient if you're locked up, and how you make that contact, and do you know about it right from day one. So I think we need to see just how that sector feels that their involvement, because I know they have an involvement, but I want to know how effective they believe that actually is.
The report seemed to indicate that the gentlemen concerned were made aware, and certainly one who had prior issues was made aware, but yes, it'll be interesting to hear from
there's
the Samaritans to see how, you know.
There's three sides to every story,
There is,
unfortunately.
There is. And I think it would be appropriate also, as we consider these issues at this point, because of the correspondence we've received, that we would express our condolences to the men's families.
Yes.
And actually, I suppose our thoughts to the officers, some of whom were very traumatised at what they encountered in those events. But certainly we're very sorry to hear of anybody dying in custody. Right.
Chair, that widens out into the much wider argument about the appropriateness of the particular custodial sentences and what is happening further back down the chain, either at court level or indeed further back down the chain at health as well.
Yeah. Which again ties into our inquiry.
It does.
Right, well, certainly I think this is an issue that we will revisit. If we could draw your attention to item 13, which is corresponds from the Committee for Finance to the Committee for Justice at pages 192 to 195 of your meeting pack, which is regarding information on the Interim Public Sector Transformation Board. Can I seek your agreement to note this item and consider writing to the Department of Justice to request a copy of the transformation proposals? Well, I think we've received those, have we not?
did. They're in the meeting.
Yeah,
They're
I
in
think
the
they're
table pack.
paper, yeah.
They are. Not an enormous table pack, which proves our edit.
Item 14 is correspondence from the Committee for Finance, the Committee for Justice, which is at page 196 of the meeting pack, regarding a request for a formal response on whether briefings have been requested or received from the Department of Justice on post-budget allocations, departmental business plans and June monitoring bids. Certainly we received that. The response was sent on the 21st of June 2024, which forwarded our documentation to the Committee for Finance following a committee agreement via correspondence. So are you content to note?
Good.
Thank you. Item 16 is correspondence from the Committee for the Economy to our committee at pages 202 to 204 of the pack. So this is about correspondence from the Association of British Insurers about transparency relating to insurance premiums in Northern Ireland. The Association of British Insurers has requested to jointly brief the Committee for Justice and the Committee for the Economy on this issue. It should be noted that in the course of their correspondence they indicate that, I suppose due to competition and lack of data, they can't and don't have information with regard to premiums and the price of premiums across the jurisdictions, but they have information with regard to claims and the differences in claims between the jurisdictions. So I just would flag that up and ask. So they've asked for a joint briefing between us and the Committee for the Economy. Do members have any views on whether you want to proceed with that? It's not our core business. However, I know some members have expressed an interest. So does anybody have any views on proceeding with that or otherwise?
Chair,
Yes, Justin.
I have a strong view about getting to the bottom of why the premiums in the north are higher than they are anywhere else in these islands.
Well, that's kind of why I'm bringing it, Justin, because I know that, I mean, we all expressed some concern about the premiums, and I know that you particularly had concerns around this. So when this came in, it's not our core business, but I wanted to give members the opportunity. I'm not sure that a formal meeting is going to be the way forward, and I wonder if it's one of those ones where a briefing is arranged and members who are interested and available would attend, rather than a formal committee that would have to be arranged between both committees, and actually they meet on different days again, which proves difficult. Deirdre?
Yeah, no, I would just agree with that then, just to give people the opportunity that want to engage. And I did meet them in April as a party in terms of it, and it's because of they said the costs are down to technology now that goes into cars, and the parts and stuff have increased also because we are more rural. But I think it even goes beyond that in terms of the premiums and trying to get, because they're paying out more now, to try and maybe, but I think a briefing them would be good then, to maybe just for those that are interested to get into a bit more detail and to do that between ourselves and Economy for those that want to.
Just to be clear, Chair, is the Economy Committee going to take this on as an item of their own, and is the invitation just that somebody, anyone from this committee that has an interest could join in that conversation? Is that a way of doing it? Puts it on a more formal basis.
It does. I think the issue was, sure, that the request actually came from the Association of British Insurers to both committees. So the Economy Committee then sent it to us. I suppose our view, I mean, Caroline, what do you think here?
Well, it's entirely up to members. They've requested a joint evidence session with the two committees. However, I think an informal session could work well, and then members can attend if they're able.
Justin, does that work for you?
What are the realities on a joint evidence session with two committees? How the practicalities in terms of how that can be convened?
It's quite difficult. We've just been having this conversation about the NIJAC stuff too. So our committees meet on different days. So it's going to be, and bearing in mind all members are members of a second committee, then it's going to be difficult to run a concurrent meeting. It's different when we're having one with Health because they meet at exactly the same time as us in the room next door. But Economy meets on a Wednesday. And I know that other members will have committees, so I think it doesn't preclude us from having the meeting and gleaning the information. But probably rather than have a formal meeting, it affords us an opportunity that people who are free and interested can go, because otherwise we're going to struggle to schedule it on the basis that the committees meet on different days and everybody's got two committees to attend.
I don't know. I know when we met them it was on Zoom, because I think some of them come in from England and Scotland. So I'm assuming it'll be a Zoom thing. So we either arrange an informal briefing between the two committees or exchange the contact details with them just for individual members to meet with them themselves, whatever people think. Is there an interest on the Economy, or did they just send it to us through?
They were unsure, so they were forwarded for Committee for Justice consideration.
I think that there's no doubt Assembly members have expressed concern in the House over the cost of insurance in Northern Ireland. So I don't consider there's anything to be lost by the Economy Committee and the Committee for Justice having a look at the issue. Nothing to be lost. And I think that we should arrange for an informal meeting that anybody from the two committees who wishes could attend.
Yeah,
Yes.
I agree with
I
that.
I
Yeah.
agree with that, yeah.
Justin, happy enough?
I feel it's a bit laissez-faire for the issue that it is. I would prefer a joint committee meeting on it, but I'm only one member, so that's my preference.
Yeah, I just think in practical terms, it's inordinately difficult to manage. And the Economy Committee has been equivocal thus far about whether or not they're going to proceed. So I think I would rather proceed with an informal meeting, and albeit it will not be hand-sorted, it still affords members the chance to glean the information and ask relevant questions, and actually it means then that the briefing is actually taking place rather than not, because in a formal committee setting it could be very difficult to schedule. So I understand your preference. I just think on this one it could be very difficult. And I'd rather a meeting took place than not. Morris?
Thanks very much, Chair. I'll be along the lines of Justin and the importance of the meeting, but I think it's more important to have a meeting in the first instance, and if it's necessary thereafter to have a formal committee meeting and bring them in front of the committee, then so be it. But for practicalities, I think we should proceed with what you're suggesting in the meantime.
Yeah, I think if members who attend find something of note that really this committee needs to consider formally, then, I mean, I would anticipate that there'd be space in any other business for members to report back, for the members who have attended to report back, and then if we need to schedule a formal meeting for us, then we can do that. Does that satisfy you, Justin?
Okay, yeah.
That's great. Thank you. So can I refer you to item 17, which is correspondence from the Committee for the Economy at pages 207 to 209 of the pack regarding correspondence from the Federation of Small Businesses about the arbitration bill. They had expressed some concern about the short notice, really, to consider with a significant issue in their view. Now, as I recall on this one, I mean, I have some sympathy for them, but as I recall on this one, I think actually the department and us had very short notice in this one, isn't that right? This was one of the ones where actually everybody had short notice. Yep. And people were a bit caught on the hop with this one, so I have sympathy for their position, but we share it. we were all given short notice. I suppose at this stage the bill has fallen. We'll see if it returns, and if it does, then we'll give further consideration to FSB and be in touch with them again should that bill change in format or content. Yep. Members content to note?
Yes.
At item 20 in the correspondence, which is at pages 216 to 218 of the pack, there is correspondence from 31-8, which is a charity. They are expressing concerns around sections 12 to 16 of the Justice, Sexual Offences and Trafficking Victims Act, and 31-8 has requested to brief the committee on the matter. Just as a reminder, we've written to the department to request an update from the Minister before the summer recess as to what she's intending to do in terms of the way forward following the judgment, and that response is at page 20 of the tabled pack. So you'll see that the Minister has indicated she hasn't made decisions yet. So I don't know where this leaves us in terms of if the Minister takes a decision over the summer to appeal, then the issue would be sub judice, I presume, which means we really couldn't.
Is it until it's been
Yes,
dealt
couldn't.
with
So
the court?
I don't want to make promises to 31-8 until we can be certain that we can fulfil them. By and large, would members welcome hearing from 31-8 once decisions are made with regard to an appeal?
If it will be them and others at that stage.
Yes. To be honest, that's my view. members, obviously in this one, and I said on the floor of the House, I think that this one doesn't reflect well on any of us. I appreciate that the bulk of this committee was not involved. However, our predecessor committee did the best they could. I think the department was coming with good intentions, but I think that there are lessons for everybody in this one. And if we're going to look at it, I think we need to look at it from everybody's point of view. I think we should look at it. But once the judicial process is over. But I think there are issues around what happened in the department and the advice they brought. I think there are issues with what happened at the committee, and what happened in the Assembly and how the Assembly was scheduling business. I've said in advance of this meeting, at the time I was Chief Whip of the DUP, the Assembly was meeting 3 times a day with committees on top of it, and sometimes committees were meeting in the course of the plenary. So members were faced with preparing remarks on legislation whilst also trying to prepare for committees that were happening at the same time. The Assembly was sitting very late into the night, and the work environment was inordinately difficult and actually proved difficult to scrutinise legislation, and members highlighted this at the time, and certainly I raised it at the Business Committee on behalf of Democratic Unionist members. My concern was that we were sacrificing quality of legislation for quantity of getting legislation through the House, and I think this has been borne out here. Despite everybody's best intentions, there were unintended consequences that were missed. And if there's going to be a review of this, I think then everybody needs to take it on the chin and look at it, because, you know, everybody was let down here in one way or another, and we need to do better. So if we're going to look at it, yes, I think we should look at it in the round and consider everybody's position and what happened, so that, you know, in trying to do our best, we don't get ourselves into those circumstances again. That's my view. And that is no criticism whatsoever of the predecessor committee, who only have access to what they're given, and were trying to do their best under difficult circumstances, because of how business was being scheduled in the House as well. So
I think also fair to point out, Chair, and if there is an appeal, it's at that stage when we get the result of it,
yes,
we will see the total picture, because that's the end of the line. This
yes.
This is potentially not the end of the line.
No, I think a decision to meet with 31-8 and whoever else, if we look at this, needs to be put in abeyance until we know what the decision is around an appeal.
Yes.
If an appeal goes ahead,
We have to wait for that.
we'll wait for that. If an appeal doesn't go ahead, I think that does give us a chance,
yes,
in terms of our post-legislative scrutiny, to look at what went wrong. And I think that's in everybody's interest and a constructive way to approach it. You know, that this is not about apportioning blame, it's about trying to prevent mistakes
in the future
like this from happening in future. So everybody content with that approach then?
Great.
And we can go back to 31-8 and explain that. So are members content to note the other items of correspondence as set out in the memo, or do you have any comments you wish to make on any of them? There's one there from JMK Solicitors with regard to the minor settlements.
Oh yes.
This is the one where I think we received notification at our last formal meeting that the department was not going to legislate on this issue. I see that JMK is quite vexed about this circumstance, but as I recall, the reasons we were given was that there was a very small evidence base, and most of it was anecdotal.
Would it be helpful, Chair, if they were to be able to communicate directly with the department rather than using us as an intermediary?
Yes, and it might be helpful to provide them with that information so that they can. I understand their frustration. However, it seemed to me that the department's rationale was very clear.
Yeah. I would propose then, Chair, that we encourage them to communicate directly with the department over this particularly, I don't want to use the word small, niche area, and if that doesn't resolve the matter for them, then to come back to us.
Members agreed?
Yep, great.
Thank you. I just want to make sure, is there anything else on this? Quite a lot of correspondence. Jack we've dealt with. PSNI cultural audit we can note.
Just to know there's the update on the budget stuff and obviously the transformation board where there's bids that have been submitted. So
Yeah.
again, it will be good to touch base in the autumn. I know they say it in the report anyway, for bids that are successful, to just get an update in terms of what the next steps are going to be. Obviously, there's going to be the funding next year as well and the year after. And I know I was at finance yesterday where we had the transformation board
Right.
in, or those that are working on the interim transformation board. But obviously they're trying to encourage cross-departmental bids. So it'll be good to see, and I know
Some of these are.
the Justice, whoever was in the last time, going through the business plan and stuff, they had said that there are bids between Justice and Health.
There are.
So just once we know what's being approved or not, it would be good to kind of get more of an update on those programmes.
Yes, it would. And I see there's a fairly robust letter from the Minister and to the Minister of Finance to indicate that one of those bids shouldn't be really a justice bid because, or considered as a justice bid
Yeah.
because it's covering numerous departments. And to be honest, I think she's absolutely right in that one. Right, can I ask you just to turn to your tabled pack? Again, it's just to draw your attention to the fact that the Minister has responded to our request for information about decisions around the review and has stated around the judicial review, and she's still considering that. Also in the tabled pack at pages 22 and 23, the Department has responded to the Committee's request for more information as a result of the oral evidence session, data which you've referred to. Are you content to note that item, or is there anything you want to raise from within that?
Like note it, but we'll want an update then in terms of successful bids, and just a bit more detail then in the autumn.
Yeah.
And I think on the other one, sorry, on whether the Minister's going to appeal, if that was to happen over the summer, I'm assuming we'll still get the communication to that. Would we, Caroline, through, would we be notified via email or?
Should be.
Okay.
And presume on issues like that, because that would be an urgent issue, we could be notified in the summer. I think we should be notified about that. I'm just wondering, is that the one? I have read so much today, I'm now losing track of. We got an update from the department around not just projects and so on, but also, do you remember what asked the question about collaborative working?
Yep.
We were given that, and it's a really detailed report about the extent of collaborative working within the department. And it indicates that collaborative working has been ongoing for some time. However, what's not clear to me from that is, since then we've had a budget, there have to be conversations at a strategic level about how are we going to work together. And I just, I can't get from anybody, and actually at the probation board launch of their video yesterday, the Minister was present. It was a question from the floor. What's the extent of the collaboration, you know, in light of budget allocations? You know, what conversations are there at strategic level about what more collaboration there can be? So it was less about the detail of specific projects that have been underway for some time and more about, look, we've now got our allocations, there's massive pressure faced by the two of us. How can we collaborate and avoid duplication? And you know, and I just can't seem to get an answer.
A bit of this come up yesterday in finance. I imagine some of that will come through in terms of the transformation proposals and stuff, because some of the testing, they were just saying at the transformation board briefing that they'll be tested on 3 broad areas in terms of the bids, and obviously one of that is around its increased financial sustainability in public services, transform the delivery of public services to improve effectiveness, efficiency and meet increased demands, looking at early prevention and intervention. But they said that they will be looking at marking the kind of joint bids, and there are a number of joint bids, and also things that are scalable. So I know in this committee, like, they had talked about smaller transformation projects, but which are pilots nearly to save the work, and whether they could be scaled up. So I think maybe getting a bit more detail on those as well. Now, it shouldn't just be left to the transformation board, but I imagine that's where there is the resource to maybe start to do things differently. So that's why I'd be keen to look at the bids in a bit more detail. Obviously, if we're going to do a joint committee with health, for example, because that would be one department that Justice will be working very closely with, you know, on issues, to see what is coming up across them. And then I suppose there's the transformation of the civil service more broadly, because I mean, I did raise around even departmental teams working more closely or even collectively together, you know, shared office spaces, all of that, to try and drive a cultural shift in terms of the siloed working. So I don't know, I suppose it's just what we can do as a committee. Maybe there is that joint session with health chair, and seeing what the what transformation bids are going to be successful.
Yep. I think that's important. I just think that they keep referring us to work that's already underway or has been underway for a number of years. What's coming? You know, what conversations have you had about what else you can do now with your allocation? You had said something there that sparked something with me about the prison service, and it's just gone out of my head. It'll come to me, I'm sure. That's fine. It was just around another question that I wanted to ask around the custody situation, but it'll come to me. Right.
I think you touched on an interesting point in terms of resource and co-location of people. And it's not just it's not the business case for saving an office space or that. It's actually putting the right people in the same room together. So is it somebody from health and somebody from justice, and they have somebody works out that they have a more than 50% crossover in their work, so therefore they're in the same room at the same time.
Yeah.
No, now.
I knew if we gave you time.
Thank you. Well played. The issue was just about there seems to have been pilots around either paramedics or kind of the mental health crisis team response being available 7 days a week, 24 hours a day, and certainly the paramedics being available in prisons at the weekends and so on, or at nights, and that's made a significant difference to them. And there was talk that would be rolled out. It started off in Maghaberry. There was talk that it would be rolled out across the other 2 prisons. And I just want to check the status of that. Because with the best will in the world, a mental health crisis doesn't just arise, 9 to 5, Monday to Friday. And that's part of the problem that we face, I think, at times. The services are available during the week. But, so if that's another issue we could cover with the IMB, or the prison service to establish what's going on with that and what services are available, because again, it's not for prison officers to deal with that, it's for healthcare professionals. Thank you. Right. At item 1025, which is at pages 124 to 131 of the tabled pack, the department has provided the committee with a written briefing on the department's 24-25 main estimates in advance of the debates that are scheduled to take place in the plenary session on Monday the 1st of July. Anybody got anything they want to raise on that? No? Can I just check what this voted and not voted is? I haven't seen a document like this before, so
page is that on, Chair?
Well, if you turn to page 129, you'll see the estimate lines and so on.
Oh, yes.
But above there, things are voted and not voted, or non-voted. Does anybody know what that means? The other thing that struck me was voted control headings in the estimates. I suppose it's hard to know what the distinction is from last year. Okay, there's the extra 95 million that went in, but it's hard to know what the differences are from last year unless it's purely inflation, because there's nothing listed. Although we do know that they kind of more or less did kind of a pro rata increase, didn't they? Does anybody have an answer to the voted, non-voted?
Perhaps the clerk would like to try and find out for us.
Yeah, I just need to check, Chair.
Yeah, that's okay.
I think some of it possibly relates to things like judges' salaries and things like that would be shown as non-voted, so, but I can seek further clarification.
Okay.
It's not fundamental, it's just to improve understanding, I suppose, as to what the distinctions are. Then the next item is the Courts and Tribunal Service Business Plan, which is already discussed, and that will be circulated in advance of any visit. At item 1027, pages 149 to 154 of the pack, the department has provided the committee with a finalised organised crime task force addendum work plan for 24-25. Are members content to note, or do you have any questions? No, thank you. And then at pages 155 to 204 of the tabled pack, this is a further report into the investigation of the circumstances surrounding another death of an individual while in custody. So again, we would express our condolences and note this item, the issues contained therein. We will follow up as we've discussed earlier in the meeting. Are members content to know? Thank you. So the committee team will continue to receive correspondence from stakeholders over the summer period, and it's standard practice to include such items for consideration at the committee's first meeting of the new session, which is going to be in September. Our members, how do members wish to handle urgent items? Do you want to do it via correspondence over the summer period?
Or is it normally done? Is it via email, is it, or?
Through chair and vice chair.
Typically, similar to the finance email that I sought agreement from the committee via correspondence, it would be a similar approach where I would email it round and seek agreement if there was something that required urgent consideration. Yeah. Or it may just be to notify also sometimes without a decision being required.
Okay, content to deal with it via correspondence, thank you. Agenda item 11 is chairperson's business. It's standard practice to delegate authority to the chairperson and deputy chairperson during periods of recess to submit views on the releasing or withholding of information in any non-routine or contentious FOI requests received by the committee, and that any such views expressed would be brought to the attention of the committee at the first meeting after summer recess. Are members content with that, or do you have any issues with that? Everybody seems fine. Also, I've received an invitation as chair of the committee to join senior members of the PSNI for breakfast and an operational briefing on the 12th of July. I've been to that for years as a member of the policing board. The invitation is at page 206 of the pack. So it's a briefing of the operation. They show us the CCTV galleries and so on, so I'll be attending that. All right. Do members have any other business?
I completely missed one. It was just with your indulgence. It was item 8 in the second pack. It was around the business plan. It was queries we put into the department, sorry, in terms of the budget and stuff going forward around the equality screening. Mm-hmm. So the department just came back saying, sorry, it's on page 23, 22 and 23 of the addendum pack, just saying that they had a constructive meeting with the Equality Commission on the 19th of June, and that will inform the approach to ensure obligations are met. But could I just ask for clarity on what that actually means? And are they going to do a full screening or a quality impact assessment on the budget? They said they're going to screen the allocations or the vast department areas, but could we just get a wee bit more clarity if members are content?
Yep.
Sorry, I completely missed it. If
No,
that. I was
look,
trying to find it.
To be honest, there was a lot of correspondence, you know. So it's easily done. I was trying to get my head around a few things myself there. Members content, yes? Thank you.
Thank you.
Date, time and place of the next meeting. So the committee agreed not to meet next Thursday due to the general election, which means that the next meeting will take place on Thursday the 12th of September at 2 p.m. in room 30. Unless an urgent issue arises that requires the committee to reconvene, in which case members will be contacted. Everybody, thank you very much for your work and cooperation, and the manner in which we've all approached our work this year. I think it's been a really constructive committee thus far, and long may that continue. And if I'm still here, I look forward to that, and we'll see you all in September. Have a good summer.
Yeah, same to you.
Thank you.
Everybody else.
Slán.
See you later.
Committee Room 30, Sound.